Hey guys, welcome to the evidence final review, and I'm going to give you some tips on the essay portion of the final exam. Now these tips are to help you think about a way of analyzing it that saves you time, effort, and hopefully helps narrow the focus of when you're looking at this particular exam. So my first tip is read the call of the question first, especially for the essays. And you don't know how important this is. I will say this: if you read the call of the questions first before you read the fact pattern on both those essays, I think there's like 2 or 3 essays. No, for this exit test, there's only 2 essays for the 2017. If you read the call of the questions first, your life will be so much easier. And on the second part of that is, you'll know what you're looking for within the dense fact pattern. See, what happens is generally a lot of students will go and read the facts first, since they come first, and then go to the call of the question and read the calls of those questions. Then they'll have to go back and reread the fact pattern, notating what they found, what they're looking for. So I say, why reread the whole fact pattern twice? If you go and look at the calls of the question and figure out, okay, they're asking me about hearsay, they're asking me about subsequent remedial measures, they're asking me about character evidence. Then when you read the fact pattern, you'll be reading looking for those issues to be spotted. See, if I were to read the fact pattern first, the fact patterns that Professor Valentine usually puts out generally start triggering all types of different rules. But you're only looking for specific things. So why not already go to the end and say, what am I looking for, and then read the fact pattern? Generally, this technique is going to save you about 15 to 30 minutes on this exam, because you won't have to keep rereading the fact pattern to see to see how to make this analysis. So here's an example. This is the 2017 call of the question for essay 1. So this is question 1 for essay 1 in the 2017 exam. This says Duggar's defense counsel plans to call Duggar's roommate, Allison Wilkes, testifies at trial as to what Duggar was wearing when she left the apartment on the night of August 22nd, 2017, and what Duggar said when she left the apartment. While admitting that Wilkes was a competent witness, the prosecutor objects to 2 things. What? Wilkes' testimony about Duggar's attire as irrelevant. So we have a relevancy objection, and objects to Wilkes' testimony as to Duggar's statement as hearsay. So how should the court rule on these objections? And we have 15 points. So for 15 points, we're looking for 2 things. First, we realize that this is a criminal case, because this is the prosecution objects. Okay. And they're asking us first about Wilkes' testimony about Duggar's attire, and they say it's irrelevant, so that's a 401 relevancy and possibly a 403. Then they're asking us about Wilkes' testimony as to Duggar's statement and whether that's hearsay or not. So that's a simple hearsay analysis, and maybe it can come in under an objection. So now, reading the fact pattern, we know we're reading for relevancy about when we're talking about the attire. How is that relevant to this case? And then we're talking, number 2, hearsay. If we can get this statement in through a hearsay or a hearsay exception. Fine. So now if we were to go back into the fact pattern, we know we're looking for these 2 things. But why stop here? Because there are 3 questions with this first essay. So let's look at question 2. Question 2, it says, Duggar's attorney makes a motion in limine to prohibit the prosecution from impeaching Duggar if she takes the stand by asking her about seeking to admit evidence of her prior conviction. Okay, so we have evidence for the prior conviction. 12 years ago, when she was 18, Duggar forged her grandmother's signature on the New York City Housing Authority rental renewal form. Her grandmother was out of the country at the time, and Duggar was frightened that the family would lose their home if they didn't return the lease and sign it, and if they didn't return the lease signed by the grandmother by the deadline. That's sad, but there are people who are put in this ridiculous situation. Duggar was charged with 1 count of misdemeanor filing a false statement, which carried a maximum of 3 months in jail. Duggar was not sentenced to jail, but did have to agree to have her name removed from the lease. Oh no. Since that time, Duggar, while known to work for Mickey Bleecker, whom the police suspect may be dealing drugs, has not had any further arrests or charges filed against her. So this is 12 years ago, 3 months, and she has not any charges filed against her. Seems like we're talking about 609. So, what do we learn from this fact pattern? Well, we learned that we're looking to impeach Duggar from taking a stand, if she takes a stand with a prior conviction. And we learned that we're probably going to be talking about the prohibition against character evidence, but we're going to try to impeach this witness under 609, prior conviction for their character for truthfulness. And Duggar is a defendant in a criminal case. Does that matter? How does that change our analysis? Is this conviction a stale conviction? Is this conviction within the time frame? But more importantly, to this particular question, and please understand, this particular question, look at this. You don't need to read anything else. This is the fact pattern for this question, in the call of the question. Now, some students would have read the whole fact pattern, would have read this, and then may read the fact pattern again to see if there's any other things you need to answer this question. But you don't, because it's all here. This question 2 for essay 1 is itself a fact pattern, a question, all encompassed into one. You don't actually have to, it doesn't seem like to answer this question, you even need to read the rest of the question. Now, I would read the rest of the question, but understand, here, it seems to be all here. Everything you need to answer this question. I don't know what other information they can give you that would change your analysis, but here, it seems pretty clear. If this is the fact pattern, this small little fact pattern for this particular question, then the other facts and the main fact pattern are irrelevant. And this question is worth 20 points. More than the first question, because the first question to total is only worth 15 points. Now, this is question 3 from essay 1. The prosecutor seeks to have Sergeant Smith's testimony as to Victor Vannick's statement to him the morning of April 23, 2017. The defense objects that the statement is inadmissible hearsay and violates Duggar's constitutional rights. So part A is worth 10, but part B is worth 15. So together, this question is worth 25 points and is the largest point total of all the questions. So we know Sergeant Smith is testifying as to what someone else said, Vanwick, so we know this is hearsay because the call of the question told us, and we know it's going to be a confrontation clause issue because that's how it would violate Duggar's constitutional rights. But here, understand that now you'd have to go actually back into the fact pattern, the initial fact pattern, to kind of suss this out, to try to understand, see what the facts say about these two particular issues. But get this. Question 1 is about hearsay and relevancy. Question 3 is about hearsay and confrontation clause. And question 2 is kind of a separate little fact pattern that, even though it's related to the overall fact pattern, you don't really have to read the fact pattern to answer question 2. So some students would just go into question 2, answer that based on that short set of facts, and then go back into the fact pattern, understanding that we're looking for relevancy and hearsay to see if we can make this thing work. So we now, before we read the rest of the actual fact pattern, we now know exactly what we're looking for, exactly the facts that we're trying to point out, and what we're trying to actually accomplish with the call of the question. Again, the calls of the question direct us to what we need out of the fact pattern. So that's why I suggest you never read the fact pattern first. Always try to figure out what they're looking for. And again, this saves between 15 and 30 minutes on the exam. So if you're a slow typer or if time is a problem for you, this is one of the ways that will help you save a tremendous amount of time. Because a lot of people are going to be reading that fact pattern 2 or 3 times, where you would only have to read it once. Read it once, take notes to it, and then answer these questions. My tip number 2 is that you can't lose points on this exam. You can only gain points. So here's an example. Let's talk about presence, impression, and excited utterance. A lot of students say it's very hard to know the difference between the two, right? But let's say you're just one of those students who don't know the difference between the two. Question comes up, how do we distinguish which one to do? Well, here's a hint. You do them both. The professor's not taking off any points for wrong answers. For the multiple choice, she is. But for the essay portion, if you put 10 answers there, and guess what? All 10 of them, or 9 of those are wrong, but the 10th one is correct. You're going to get full points for the 10th one. Similar to what the bar exam do. Now, that's an extreme example, but here, if you have enough time to do both analyses, then why not? Because you're only going to get credit for the one that's correct. It's not like she's going to give you credit for one and then take off that same credit that she's giving you because you did a wrong analysis. So here you have 2 bites at the apple. Why not use it? Why limit yourself, especially if you have the time? Now, if you don't have the time, I would say pick the best one, pick one that you think is correct, do that, and then, spend the whatever last amount of time you're doing. If you're typing to the last part of the test, you should be typing out that second analysis to see if you can get the points. That's the way I would do it. But I'm not going to try to leave any points on the table. I'm going to do analysis 1, give you analysis 2, and move on. And again, when you're taking the bar, this is what you should be doing when you're taking the bar. If you're not sure between 2 particular bodies of law and you think they both apply, do both analysis and get all those points. Don't leave them on the table. This professor doesn't take points off for wrong answers. The only way you lose points is by not having an answer on the page. If you don't have the correct answer on the page, you're not going to get the points. My third tip is probative versus prejudicial effect. Now, a lot of students have a problem with this, and they argue that it seems I don't want to say conclusory, but it's problemsome. It's difficult in trying to determine what the probative value versus the prejudicial effect. So I'm going to tell you the way I think about it. And it may help or may not, but this is the way I think about when we're talking about probative versus prejudice. So probative, the general question I ask is, why is it coming in? Well, why do I want this thing to come in? And that's the probative value of it. And then prejudice, I'm asking, why should it be kept out? What's the policy reasons for this thing being kept out? Now let's take something like 407 subsequent remedial measures. The probative value, and this is just from the rule, is impeachment, or if disputed, proving ownership, control, or feasibility of precautionary measures. That's my probative value. This is what I wanted to come in for. Now let's see, what's the prejudicial effect? Well, the fact that the jury may use it as proof of negligence, culpable conduct, defect. If the jury uses that, that's a prejudicial effect. And let's not forget, the policy concern is that we want people to fix things that are broken. So in your prejudicial effect, you would say, this is the we don't want the jury to misuse this evidence as proof of negligence or culpable conduct, because the policy is that we want people to fix things that are broken and not be held against them. So this is the balancing test. This is what you're balancing. And again, you can say this for hearsay, you can say this for character evidence. You're always balancing what you're bringing it in for versus what you should be keeping it out for. And then obviously you're going to make an argument of determination. My fourth tip is to stay calm, relax, and think positive. Because, again, I know there's a lot of anxiety. I've taken the evidence test before. I've taken, the constructs test before. Not this one, but when I was in school here. And, staying calm, relaxing, and thinking positive goes a long way to just helping you stay calm, and it helps memorization too if you're calm. If you're excited, you have a lot of things going on, your adrenaline's up, and things are just flashing in your mind. But staying calm helps you really get through it and helps you memorize what you need to memorize. The one thing you should take away from this test, from this presentation, I should say, is to stay calm, relax, and think positive. Because this will probably be the most helpful thing I can tell you today. So listen, my name is Nate. Thanks again for watching, and good luck tomorrow on your evidence exam.